Good evening, everyone. Welcome to the webinar tonight on the new aged care laws. My name's Jackie Broman. I'm Special Counsel at SPG Lawyers. A little bit more about me. So that little logo that you see on the side, the blue and the black little figure 8, I am an accredited specialist in wills and estates. I got my accreditation in Victoria about 9 years ago. And if you think of lawyers like the medical profession, you've got GPs and then you've got specialists. It's not a strict correlation, of course, but I've done 3 years of extra study and then a 12-month accreditation process to get that little logo. So accredited in wills and estates. If you are looking for an accredited specialist in any particular area of the law, that is the logo to look for. Of course, Queensland issues them as well. So that's just so you know a little bit more about the legal industry, and so you know, because it's hard to tell sometimes. A professional is a professional, aren't they? Maybe not. So we've got aged care reforms coming in on the 1st of July. These have been a long time in the making and they're finally coming in at a crucial point in many ways, because aged care is potentially more expensive than raising a child these days. And you can see the stats there. Those who reach 65, which is pretty young, a third of people, males over 65, end up in aged care, and half of women over 65 end up in aged care. So let's be a little bit prepared, or at least aware of what to expect, either for our aging parents or ourselves. So estate planning in 2025, my God, 2012, what am I saying? So it's not just a will. My God, people ring up and say, I just need a simple will. And then we dive in. So we need to look at property ownership. These days, maybe back in 1985, it was simple. Now we own more than we ever have owned before, ever. And we own things in more complex ways as well. Tax laws have gotten so much more complex over the last 40 or 50 years. No one can deny that. Superannuation didn't exist 40 or 50 years ago, or not compulsory anyway, not the way we have it, highly regulated. And for a lot of people, their biggest asset, once you take into account the life insurance on it as well. Of course, this topic, we are living longer and not dying suddenly most of the time. We have a period of degeneration, hence aged care, but also hence powers of attorney are far more important than they ever were. Also, if we just had an accident, we're more likely to survive an accident, but you know, how long will it take us to recover? How long are we out of action? Who keeps our life going for us until we can come back to our life? And who makes our healthcare decisions while we're in a coma or recovering from a stroke, or whatever may have happened? And do they know what your decisions are, that you know, how you would want your care in what scenarios? Trusts. So along with property ownership, more people have family trusts these days, or unit trusts, or various other forms of trusts to build wealth in. Or people are looking to have more complexity in their wills and have trusts in their wills. Testamentary trusts, life interests of some kind, special disability trusts, protective trusts, education trusts, all sorts of things. Guardianship, really crucial. For those, of course, with children under 18, people often say, oh, I don't need a will, I don't have that much, but, you know, I've got kids. Oh, gee. Your godparents, it's not an illegal appointment. Who do your kids end up with if you don't have a will? Aged care, of course, we're talking about tonight. We need to prepare for it. And digital assets, they didn't exist 40 years ago. Most of us have some kind of online account these days. You would if you're in this Zoom meeting. So how do we make sure our digital life and all our little accounts everywhere and all our subscriptions and the photos we have saved and the works of creativity that we have developed are all recovered and then closed down, of course. So yeah, you can see it's a little complex, but tonight we're only dealing with aged care. So the reforms, how much the costs are changing. Some other little arrangements that you might consider as an alternative to aged care with granny flats, and what to consider in terms of how thinking about aged care and your estate plan could work together. So I think the costs are obviously what we're most interested in. I certainly was with the changes, that's for sure. So what people are currently paying at the moment in aged care are two main areas of payment. So they pay for their care, they pay a basic daily fee, and they pay a means-tested care fee. The means-tested care fee covers clinical and non-clinical care. And depending on the facility and the means, and if someone has the means, the choice of where they go, there's additional fees. So, you know, if they want a champagne lunch, they're obviously paying for that. But basic daily care fee, everyone pays. Means tested care fee, of course, means tested, and then additional fees. So that's for your care. And then the accommodation. So this is where most people get worried and sometimes bring mum in or dad in to see me when they're trying to help their parents think about aged care. So a lot of people get worried about the RAD. That's the bond, the refundable aged care deposit. So it has been capped at 100,000. So 550,000, I should say that right. That cap is changing. It's going up, of course. So if you were being assessed, you wouldn't pay more than that unless there was an agreement to pay more than that. And on average, people pay around 300,000 for a RAD on average, but the highest RAD I think that has been paid has been about 1.2 million, and that was by agreement. Because the person wanted a particular facility, they could afford it, they wanted extra care, they wanted the works. Or if someone can't afford to pay a bond, they could choose or could pay the daily accommodation payment. So then someone on Centrelink, most of their Centrelink would go, their income would go in the basic daily care fee. They wouldn't have the basic daily fee, they wouldn't pay the care fee, and then they'd pay a daily accommodation payment, which would probably be about 80-something% of their Centrelink benefit. Or people could pay a combination. So if they were assessed at 300,000, they could pay 200,000 and then pay a lower daily accommodation payment if they wanted to. So that's how it currently works. That is changing. The basic daily care fee is staying the same. They are getting rid of the means-tested care fees. So now all clinical care will be free. So yay, that's great. Non-clinical care will be means-tested. And then there's a hoteling supplement as well, which is means-tested. So this is laundry, those little extra things. There are new caps. As I said, the $550,000 cap is rising, but hardship assistance still applies. So people, again, as I said before, on Centrelink without assets will still be covered because the basic daily fee stays the same. All clinical care is paid for. They wouldn't have to contribute to non-clinical care or hoteling because they wouldn't meet the means test, and then the accommodation is paid in a different way. So let's compare then. So moving forward after the 1st of July, we still have our basic daily fee. No one will pay anything for clinical care. There's a means tested non-clinical care fee. So that can be falls prevention, extra things, extra services, so not actual clinical. Hoteling supplement, capped, and again, means tested. So $12 a day, $12, and it will gradually go up a little bit. But for example, someone might be means tested to contribute $4 a day. And then for the accommodation component, so for the RAD, the cap increases at 750,000. And this is the biggest thing for my work, is that you now don't get all your bond back. So they now can keep up to 10% of that. 2% every year over 5 years, maximum of 10%. There is still a daily accommodation payment. So if someone doesn't want to pay the RAD, they can pay the daily accommodation payment instead, or again, you can still pay a combination. So a partial RAD and then bulk it up with a daily accommodation payment. So some of the means testing for the care. So to have to pay for the non-clinical care, the means test is actually on the hoteling supplement. So you don't have to pay non-clinical care unless you're assessed at having to pay that full $12.50 on your hoteling supplement. So if you're means tested to pay the $4, you don't have to pay for your clinical care. That will be covered by the government. But for those who can afford the whole hoteling supplement, try and say that quickly, then you will also contribute to the non-clinical care. So what is the means test for the hoteling supplement? Now, unlike with your Centrelink asset test, your principal place of residence is not counted. In aged care, for your asset test, your principal place of residence is counted, but they cap it at 206,000, sorry, which will go up each year. So you can see that you don't need many assets to have to start contributing to the hoteling supplement. You only need a house and then, 30,000 in the bank, and you'll be contributing to the hoteling supplement, or income over 95,000, or a combination. All right. However, all of it is capped as well. So for your whole life, you only have to contribute 130,000 towards the hoteling supplement and the non-clinical care combined, right? So that's either for life, or if you've paid more than or up to 130,000 within 4 years, it stops, right? So all is clear as mud, really, huh? So if I just go back a slide, so daily care fee stays the same. Nothing for clinical care. If we have 238,000 in assets, we're paying some of this hoteling supplement. If you have to pay it all, then you have to start paying some of your non-clinical care as well. The assessment for your RAD happens as well on the same sort of asset test, but I'm not sure how they work the scale as to work out how much you contribute to your RAD. And we're losing 10% of that now, so we don't get it all back. All right. So some alternatives to aged care. A lot of people want to stay in their home. With the new aged care reforms, there's actually more money to help people stay at home. So there is more at-home help. There's heaps more money being thrown at clinical and non-clinical care for people in their own homes. So that's a potential. However, this is another potential that I wanted to draw people's attention to is granny flat arrangements. So there's two aspects to this. A lot of people are concerned that if they sell their house, they then have money in the bank and it's counted for Centrelink then, right? So as I said before, with the asset test for Centrelink for a pension, the principal place of residence is not counted. And that also incentivizes people to stay in their own home. However, there's a way around the gifting rules for Centrelink. So if you sold your own home and you ended up with the, few $100,000 or whatever in the bank, and then you can't give it away so that you get your assets back down to keep your pension because there's gifting rules. So you can't gift more than $30,000 over a 5-year period with Centrelink or they'll penalise you. There's an exemption and that is for a granny flat. So if you didn't want to sell your house and pay a bond to go into aged care, you can sell your house and pay your kid to care for you for life, right? So if you wanted to move in with your family, either into their own home and they alter their home for you, either they could extend it or they could put a granny flat in the back. It's legitimate to pay hundreds of thousands of dollars for this to happen, and Centrelink will not count that as a gift. Because of course, when you're paying your child this money to improve their house or put a granny flat onto their property, it becomes theirs. So you don't own the granny flat and you obviously don't own the extension on their house if they build an extension for you or any upgrades that they do for you. But that is another interesting option for people to consider. So keep that in your back pocket because we're coming back around again to aged care. So estate planning considerations. As I said, the bond is the main thing that we think about in terms of estate planning because it is a fair chunk of money and we used to get it all back. But it only ever comes back to the estate of the person that has passed away. And that's not changing. So that is still an ongoing problem, that if mum or dad doesn't have the money to go into care and someone else fronts that money for them, they've basically lost that money because it goes into the estate. So it needs to be loaned and people need to understand this. You need to loan that money to mum or dad to go into aged care, or else it's a gift and then it just goes into the estate through the will and it gets split between all the kids. It doesn't come back to the kid who paid it. Or, it could be blended family. It could be a new spouse. There's a lot of scenarios. We'll go through a few scenarios in a minute. And the RAD only comes back to the estate with a grant of probate. So you used to be able to get a grant back, particularly from the aged care facilities that were not for profit, if the bond was on the smaller side and if there were indemnities signed by the estate, you didn't have to get a grant of probate. The for-profit aged care facilities always wanted a grant of probate, so that's not changing for them, but it's definitely now for every aged care facility. They won't release a RAD without a grant. So even if only a partial amount has been paid, you still need a grant to get it back. So recently I acted for a man who paid only 50,000 of the 250,000 that his wife was assessed. She died within weeks of going into care, so he'd only paid the first part and hadn't paid the rest. So we hoped and we asked and we begged. We said, it's only 50,000. Please don't have to make us have to get probate. But no, we had to get probate. So bear that in mind as well, that if you're trying to set your estate up to avoid probate, paying a RAD sort of defeats the purpose. Not that probate can be the worst thing in the world, of course. It's not a death tax. It's just administratively burdensome. So it takes 3 or 4 months, whereas if you didn't have to get it, you could do everything within 2 or 3 months. So let's have a think about some scenarios. A lot of blended relationships these days. So this couple, they're both in their 80s. They've found love again late in life, second marriage for each of them. They've been married for 10 years. So they got remarried in their 70s. Lovely. Each have children from their previous marriages, of course, and they kept all their property separate. He was quite wealthy, she was not. He can't care for her in their home. She needs to go into aged care. He's staying in his house. The house is in his name. She's assessed at having to contribute $300,000. Because she's not paying, that interest is accruing on it. She and her family hasn't chosen to pay the daily accommodation fee, which they may have to do. She can't pay it, of course, and he's refusing to pay it, and her kids are jumping up and down about it. He has been given advice not to pay it because if he pays it, it goes into her estate. She doesn't have capacity to sign a loan agreement. So he doesn't want to lose $300,000 into her estate to go to her children. He wouldn't get it back. So he's not paying. So the aged care facility is like, this has to be sorted out. The kids aren't doing anything. They can't get anywhere. Her husband doesn't have to do anything about it. So the aged care facility could take a QCAT application to get the kids removed as powers of attorney because they are ineffective. They can't resolve the problem. Or the other problem that then arises is that, well, no, the children could say that the mother is now separated because they're married but not taking financial responsibility. So her children could take family law proceedings for a property settlement from the husband. Pretty horrendous stuff just to pay for aged care. But then this was actually a real scenario, not one that I've come across, but one that a colleague of mine had. But then husband ended up dying anyway. So his estate goes all to his kids. Wife is in aged care, can't pay for it. Has been assessed way too high. So effectively then really she should have a reassessment at that point, given that he's passed and none of his assets in his house can't be counted as her principal place of residence anymore. So that probably solved the problem. But what a problem to have later in life, having your wife's children railing and jumping up and down at you. And how heartbreaking it is also to watch your wife go into aged care and then be able and take that stance. No, I'm not paying. Another scenario. So in this one, wife goes into aged care, second husband, he's happy to pay this time because the wife hasn't lost capacity. So wife signs a loan agreement. So all good. That $200,000 is going to come back. But the $200,000 is only part of what was assessed, and the daily accommodation payment has to make up the balance. The daughter is the power of attorney, daughter of the woman that's in aged care. Instead of paying the daily accommodation payment out of her mum's Centrelink payments, she directs that the daily accommodation payment comes out of the RAD. So the RAD is getting whittled away. Second husband who paid it doesn't know that this is happening. She dies. He expects the RAD to come back to him under the loan agreement when she dies. There's nothing left because it's been whittled away, so he loses his money anyway. So there is some possible action potentially that he has against the power of attorney for her actions as attorney. However, she has to act in the best interest of the person who appointed her, being her mother. She doesn't have to act in her mother's husband's best interest. So another interesting, not so great scenario. All right. New romance in aged care. Oh my God. This happens more than you think. So this scenario, elderly woman enters aged care. Daughter pays the bond, no loan agreement. Daughter's happy to give mum the money because she's an only child, no problems. When mum dies, she gets it all anyway. However, mum meets the love of her life in aged care. And although daughter's a little reticent, she doesn't really mind. It's nice, nice romance or whatever. But this new man's children whip them out of aged care one day, take them to a registry and have them married. They both have capacity. They're allowed to get married, but there's huge estate planning consequences for that. So now when the woman dies, there's no valid will because she's married. Her will is now invalid from prior to the marriage. She dies without a will. Under the laws of intestacy, who is entitled to her estate? Her husband. So new husband gets the entire amount. So another little interesting scenario there. So all sorts of these little things can arise. They are sort of some of the worst case scenarios, but you know, sometimes life is like that, and you know, it's stranger than fiction, really. Other things to be thinking about with aged care is the obligation on the power of attorney. So it can be, when we're caring for our aging parents, quite a significant burden that could leave us potentially liable for a multiple range of scenarios. So ademption is an interesting concept. If in a will, someone leaves a specific piece of property to someone, but that piece of property doesn't exist when the person dies, that gift is deemed. So for example, my parents have two investment properties, leaving one each to my sister and myself. When they go into aged care, they're going to have to pay for that somehow. It's probably best to sell one of the investment properties because the CGT can be taken care of at that point instead of us inheriting CGT issues. Principal place of residence has been exempt. Far less CGT will accrue after they leave. So one of them has to be sold. So if I'm the power of attorney and I go and sell the investment property that's gifted to my sister in their will, then that is deemed from their will. She misses out on that gift entirely. So ademption is a problem that we need to think about. There are some exceptions to ademption, and they've just been recently built into legislation here in Queensland. So having proper advice about that sort of thing as an attorney is really important when you're selling something for the principal who has appointed you. Other scenarios, of course, as well are like this scenario: elderly woman, new marriage, no valid will because the will has been revoked by the marriage. Or the scenario I was talking about with my own parents, I sell the investment property meant for my sister, and my parents can't do a new will because they've lost capacity. There is grounds potentially to do more statutory wills. So the attorney then might make an application to court and say, if my parents were able, they would change their will and this is what they would do, and the court can make a new will. So in this scenario with this lady who's married this new fella, the daughter may have been able to go to the court in that scenario and say, hey, mum wants to just reiterate her will from prior to her marriage. She doesn't need to do a new will, but that should still be validated. So you can do a statutory will with the court after someone has lost capacity. So that might become something that we do more as an estate planning process, working with attorneys after their parents have lost capacity. We might have more executors after the death of someone investigating the actions of the attorneys for their duties getting someone into aged care. So this might be like this scenario where the daughter had whittled away the RAD. And then this new aged care reform bill act now creates a new aged care support person. So even if you have a power of attorney, you will then have to be registered with a particular registration method with the federal body for aged care to be able to support someone in making decisions in and around aged care. So it's an additional step for attorneys now too. You have to get on that register. It's great that there will be a national register because currently there is no state or national registers for powers of attorney anywhere. So that's a good thing. And if you already have a power of attorney, it will be easier for you to get approved as that support person for aged care. However, you don't need a power of attorney to be approved as that support person for aged care. So we then start having these problems where do we have different people appointed for attorney versus appointed with support person, and who has authority? So there's those sorts of problems that will potentially arise as well. Or someone gets the support registration with the aged care facility while mum still has capacity, but then mum loses capacity and you didn't do your power of attorney because you thought the support registration would be sufficient, and it's not sufficient for all the other aspects of mum's life. It's only for aged care. So then stuck again. So we've now got this interplay between state and federal law in terms of who can help someone, which could become quite tricky. And they also haven't given us any detail about the process of registration or how to apply for it or any of those things at the moment. It's a week away. Not that everyone's going to be rushing in to register themselves as a support person, but it's got to be done at some point. So there we go. We can now go to some questions. You can take note of my email address there if you like, because you can email me directly after this. If you have any other questions, the replay will come out to you directly, so you don't have to email me for that. That will come. But no one has put any questions through while we're talking. So I hope your brains are buzzing a bit. I am going to stop the recording. So those of you who didn't attend live, sorry you can't ask a question, but you can email me. But yes, I'll stop the recording so that people can raise their hands and ask a question if they like.